Welcome to this channel. Today we continue our discussions on the recent amendment and introduction of new ordinance in relation to Crongland in the Turks and Caicos Islands. In episode 47, we dealt with the amendments to the Crongland Ordinance. In this episode, which will be part 2 of episode 47, we will deal with the Crongland Residential Conditional Purchase Lease Arrears and Means Profit Amnesty Bill 2023, and we will give you the rationale and explanation for the bill or for the ordinance as explained by the Attorney General of the Turks and Caicos Islands. This explanation was given in the House of Assembly and it was subsequently reported by the TCI Sun online. But before I do, my usual disclaimer: nothing that I say in this episode or in this video is legal advice, should not be construed as legal advice, and for legal advice, please contact an attorney of your choice. Welcome back. In relation to the Crongland Residential Conditional Purchase Lease Arrears and Means Profit Amnesty Bill of 2023, quite a mouthful, the Attorney General said that this bill seeks to provide amnesty for a period of 2 years to facilitate implementation of the new terminal options recommended by the Crongland Review Report to regularize conditional purchase leases and to write off the arrears and means profit in respect of residential conditional purchase leases. She explained that Class 4 of the bill sets out several terminal options, such as conversion of the CPL or the conditional purchase lease to freehold title without having to pay the arrears, payment of the freehold purchase in installments in certain circumstances, conversion of the CPL to long lease, subject to conditions, surrender of the lease, or to shrink, reconfigure, or in exceptional case, exchange the plot as a preliminary step before exercising any other option. According to the Attorney General, a person who holds current registered residential conditional purchase lease or a person whose residential CPL has expired but who remains the registered leaseholder under this legislation, lessees will be able to apply to the Crongland unit to convert their CPL to freehold title without having to pay arrears and mean profit. The increasing influence of foreign investors buying up houses and land and turning them into rental properties is exacerbating the housing shortage, driving up prices and putting homeowners out of reach for many locals. according to the Attorney General. She went on to say that to compound this, Section 36(2) and 3, and this is of the Crown Land Ordinance, require the holder of a CPL to pay all arrears in rent and means profit before they can acquire freehold title at a revised value, which has become cost prohibitive. This is also exacerbated by the fact that the large majority of these cases relate to leases that were granted before the commencement of the CLO in 2012. CLO referring to the Crown Land Ordinance. And as a result, there is often an enormous difference between the freehold purchase price stated in the original but expired CPL and the revalued price of the land. Further, the requirement for payment of the outstanding rents and mean profit, compensation for unauthorized use or occupation imposes an extra financial burden on the applicant, as the arrears and mean profit are often in the tens of thousands of dollars and beyond. The arrears also have a serious adverse impact on the ability to borrow the funds to purchase the freehold, as the financial institutions are unwilling to have their collateral being burdened by extra lending to cover rent arrears. Therefore, according to the AG, in addition to increasing the discount on residential Crown land, the bill includes an amnesty clause to write off the arrears and means profit to make the acquisition of freehold title more affordable. She went on to say that the bill provides for payment for freehold title in installments, providing that a person resides in the islands and occupies the property as his primary residence at the time of the application. B, the freehold purchase exceeds $75,000 and the applicant demonstrates his inability to raise funds by borrowing secured by way of charge or standard loan terms. And C, this option is implemented under the Purchase of Land Extended Payment Agreements Ordinance. She said that the price of land continues to increase and some individuals are unable to qualify for a mortgage in order to secure the freehold title to the land. Although the government does not favor selling land on credit terms with default payment or an installment plan due to the risk involved and the government's poor track record with respect to credit management, this is seen as an option to bring finality to the problematic expired CPLs and exception case basis. Specifically, this facility has been restricted to cases where the property is being occupied by the applicant as their primary home, as this is the category of greatest social need and will align with the constitutional emphasis and protection of shelter. To ensure that the government offers this facility only where the individual is unable to get the funds together to buy the freehold, she said the bill stipulates that it shall be available only where the freehold purchase price exceeds $75,000 and the individual is demonstrably unable to obtain a mortgage loan. She went on to address the issue of converting CPL or conditional purchase lease to a long lease, and she said lessees will be able to convert CPL to a long lease provided that 1. That person occupies the property as his primary residence at the time the application is made. That person provides evidence that he has no realistic prospect of being able to afford to buy the freehold title. And 3. That person provides evidence that he suffers from a debilitating injury or sickness or is over the age of 60 years. The Attorney General pointed out that there currently isn't any avenue under the CLO, Common Ordinance, for persons holding a CPL to obtain formal tenure if they are unable to purchase the freehold title. The transitional options available to CPL holders under the existing Crown Ordinance are 1. Purchase the freehold title, 2. Acquire an extension of the CPL for an additional 2 years, following which the freehold must be acquired, and 3. Surrender the CPL. It is possible that in some cases, even with the relief that are recommended above, it may not be enough for some individuals to acquire the freehold. This would therefore mean that the only possibility would be to surrender the land to the government. Consequently, the value of any development work by the individual on the land would be lost, and that the individual might also be left homeless, the Attorney General said. A long lease provides the individual with the security to remain on the land for the duration of the lease and allow that person to continue to enjoy the benefit of any house that they may have built on the land. However, the disadvantage of the long lease is that it is only a temporary measure. It does not give the individual the freehold ownership. The ownership remains with the government. This means that the individual who has developed the land is unable to access the capital value of that investment. He cannot sell it, and only in very narrow circumstances can he use it as collateral to borrow against. Further, at some point, the lease will come to an end and the person will be faced with the same dilemma once more. A new long lease could be an answer. But the problem is that during the running of the lease, the upward direction of land prices mean that the freehold will get further and further out of reach. The longer a person stays under a lease, the greater the freehold price and revaluation. The person will not get to share in any of that increase in the value of the property if he holds it under a lease. Given the above, the Attorney General said the institution of a long lease is only being permitted in instances where the CPL holder is occupying the property as his primary residence but may have fallen into arrears because of debilitating injuries or sickness, or who are elderly or without an income. In these instances, she said, the option of saving up or borrowing the funds for a freehold purchase, even with the benefit of the Islander discount and the installment plan, would be impractical. Another option that is available under the Amnesty Bill is the lease may apply to shrink or reconfigure it, or in exceptional case, exchange the plot as a preliminary step to exercise one of the other terminal options. She said, CPL holders may not be able to afford the cost to acquire the entire parcel which was held under lease, but may be able to acquire part thereof. However, this is not permissible under the Cromland Ordinance. One of the factors which is considered in valuation is the size of the lot. Continued the Attorney General. Generally, the larger the size of the parcel, the higher the value, provided all other variables remain constant. Consequently, those persons who are unable to afford to purchase the entire parcel that was originally leased to them will now be permitted to reduce their plot size, provided that the subdivision of the parcel meets planning requirements. This will reduce the freehold price, and additional land will become available for future residential use, she added. According to the Attorney General, the bill also introduces utility service certificates to permit holders of expired CPL holders to apply the grant of a utility service certificate in order to apply to the utility authorities for utility, telecommunication and other services. Persons have experienced difficulty in proving that they have a sufficient interest in property held on an expired residential CPL and were unable to apply for planning permission or obtain utility connections or other services. In response, the bill introduces a simple official scheme for the issuance of a service certificate upon receipt of evidence that the applicant is eligible to exercise one of the terminal options. There ends the explanation given by the Attorney General to the Cromland Residential Conditional Purchase Lease Arrears and Means Profit Amnesty Bill 2023. Here is where I will leave it for today. Thank you for watching, and I will see you in another video.